Hello and welcome to episode 51 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCF's litigation director.
And I'm Joanna Baron, executive director of the CCF.
In today's episode, I'll walk you through an Ontario Court of Appeal decision about border guards violating people's rights to security against unreasonable search by going through electronic devices, but also the court's use of the reasonable hypothetical that has caused so much drama in Canadian politics.
I'll explain why the new head of the Canadian Human Rights Commission has agreed to resign.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to discuss the Supreme Court's decision not to hear Jordan Peterson's request to force the Ontario Court of Appeal to hear his appeal of a lower court decision that upheld the College of Psychologists' disciplinary decision against him. I'm, of course, talking about the Divisional Court's decision requiring Peterson to undergo social media training or face further discipline that could eventually lead to losing his license. And this was a decision we intervened in on the side of free speech, so obviously we are disappointed. Peterson's written an op-ed in National Post, and the big news is that he's not giving up. He's planning to, quote, see this contemptible process through to what will almost certainly be its absurd end. He says, I'm going to find out just what sort of person will step forward to re-educate me. I'm going to see what constraints are put on my movement and the sound of my tongue while all that unfolds, and I'm going to make it as public as possible. So get your popcorn ready. I want to talk more about Jordan Peterson's response to this decision, but first I think it's worth summarizing the case here again. So in 2017, Peterson stopped seeing patients, but he remained a member of the College of Psychologists of Ontario. And the college is a regulator that the province of Ontario has given a monopoly to regulate psychology in the public interest. And that means that the college is essentially acting on behalf of government when it regulates, which is why charter rights, such as Mr. Peterson's right to freedom of expression, must be considered by the college when it makes decisions. You might recall that Peterson became world famous back in 2016 after he opposed the Trudeau government's plans to add gender identity and gender expression as grounds of discrimination in the Canadian Human Rights Act, which basically means federal employers can't discriminate on those grounds. And many people saw adding gender identity and expression as a kind thing to do for transgender people. Others saw it as, fairly harmless, but Peterson saw it as a step toward making it illegal to express the view that there are only two sexes. Or, as he puts it in National Post, and to be clear, I'm quoting here, he says, Bill C-16 made it illegal to discriminate on the basis of the made-up, neo-Marxist, postmodernist, queer theory categories of gender identity, which do not exist, and of gender expression, which is literally nothing other than fashion. So after that, the College of Psychologists started receiving complaints about Peterson's tweets, which members of the public said were transphobic or racist or sexist, and this led to the college warning Dr. Peterson that as a member of the college, and in light of your public profile, you may wish to offer your opinions and comments in a respectful tone in order to avoid a negative perception toward the profession. And the complaints didn't end, his comments didn't end, so the college investigated further. And the specific comments that the college considered were not things he ever said to patients, they were tweets or, comments he made on podcasts. And these included tweeting to an individual who expressed concern about overpopulation that you're free to leave at any point, telling Joe Rogan that a former client was vindictive, referring to Trudeau's former principal secretary, Gerald Butts, as a prick, tweeting that Catherine McKenney, the Ottawa city councillor who uses they, them pronouns, was an appalling, self-righteous, moralizing thing, referring to the actor Elliot Page by Page's original name and saying that Page's breasts had been removed by a criminal physician, and finally, commenting on a Sports Illustrated swimsuit edition cover with a plus-size model tweeting, sorry, not beautiful, and no amount of authoritarian tolerance is going to change that. So for some reason, the panel decided that you're free to leave at any point was just a joke, and so that comment was acceptable, but the rest of them were found to be possibly demeaning, degrading, or unprofessional, and therefore violating its code of ethics. And interestingly, they said these comments caused harm not just to the individuals they were targeted at, who were all, famous people, but communities more broadly. So even though he wasn't acting as a psychologist treating patients when he made these provocative comments, it was enough for the college that people might be hurt or offended by them. And so the college decided it had a right to step in and discipline him. And at first they proposed that he, quote, reflect on these issues with a period of coaching. And Peterson told them in a letter that he actually agreed with them that social media requires careful attention. But he said he'd already implemented a solution that would help him modify his tone, which was their concern. And this included consulting with his editors, his family members, and his network. And the college wasn't pleased with this response, so they ordered Peterson to enter into a coaching program with one of two individuals they had identified to, quote, review, reflect on, and ameliorate his professionalism in public statements. He'd need to pay for this through his own pocket, and the coach would be required to issue a report on his compliance. And if he didn't do this, he would face a misconduct hearing. So it's important to understand what the divisional court here did. It's just a judicial review. And the idea with judicial review is that, except in some relatively unusual types of cases, a court is not allowed to review the decision for its correctness. It's not asking whether it's right or wrong. It's just looking at whether it's reasonable. And that requires looking at the reasons and saying, was this decision justified, transparent, and intelligible? And one of the reasons for this is Parliament decided to give the regulator this power, and courts show deference to the legislative branch, or so the theory goes, by not overturning all their decisions as long as they look reasonable. So that said, where charter rights come into play, like freedom of expression, the court will find the decision is unreasonable if the decision maker didn't proportionately balance the statutory objective, which in this case is protecting the public, with the charter right, in this case expression. And this is called Dory review, and you can think of it as like a light version of the Oakes text, which is normally applied to determine whether a limit on a charter right is demonstrably justified. And I won't get too deeply into it, but Dory analysis is problematic because it basically sets up the courts to more or less rubber stamp a lot of administrative decisions like this. And, as long as the college has sort of claimed, whether in good faith or not, to have considered freedom of expression, and it looks like a relatively minimally impairing option they've chosen, then the court's just going to allow that decision to stand. And this, by the way, is also why it's not all that surprising that the Court of Appeal and the Supreme Court didn't require this to be heard again. So the main argument that was made was that this is off-duty speech. It's not the business of the college. The job of the college is to ensure Peterson's not abusing actual patients, which he obviously didn't do and wasn't accused of. And if they can regulate this type of off-duty speech, then there's basically nothing professional regulators can't do to censor professionals who step outside of the mainstream view. And so the court didn't agree with that. They said Peterson's rights had been proportionally balanced because he's still allowed to express himself. He just needs to do it in a civil tone. And to me, this is really not very logical because at the end of the day, if the college can police Peterson's tone, it means he can't really say the things he wants to say. He can't be Jordan Peterson, who is a provocative person. For example, if I said to you, I think Canadians ought to be careful about how we approach gender identity because some kids with gender dysphoria might actually just be gay or suffering from a mental disorder unrelated to gender identity. And there's no good research to support putting them on puberty blockers or undergoing certain surgeries. That message might not get very far, and it's probably not going to get a lot of retweets or invites to a lot of the bigger podcasts. But if you say, quote, hordes of surgeons are mutilating and sterilizing children, often autistic, gay, or otherwise marginalized, and when you mess with the very conception of sex, which in all likelihood is the most fundamental of all perceptual and conceptual categories, and mandate acceptance of the fact that a man can be a woman merely by saying so, then all manner of lies become not only acceptable but required. That lands kind of differently, and obviously that's quoting from Jordan Peterson's op-ed. So to quote My point is that harsh speech is going to get a lot more people interested and it's going to have a lot more impact. And frankly, it's just as protected as every other kind of speech. To quote former Chief Justice Beverly McLaughlin, the reason we have Section 2B in the Charter is to ensure that everyone can manifest their thoughts, opinions, beliefs, indeed all expressions of the heart and mind, however unpopular, distasteful, or contrary to the mainstream. And we do this because ideas that are unpopular, distasteful, or contrary to the mainstream today often turn out to be correct tomorrow. And we only get to that truth by having a vigorous debate that sometimes offends people. Now, obviously, a lot of people who disagree with Jordan Peterson are gleeful about the fact that this decision will stand, but they shouldn't be because it means that all professionals now have to fear speaking out against their colleagues or speaking out on political issues because professional regulators can now come after them with threats of discipline and just claim that their tone was wrong. And Peterson says in his article in National Post that he has spent over $1 million fighting this already, and obviously most professionals can't afford even a fraction of that to fight for their free expression. And that means this decision is going to make it harder and harder for us as a society to make good decisions because anyone with voices outside of the mainstream, whether they're on the left or the right or some other part of the political spectrum, is now going to have to, self-censor because their professional regulators will be able to come after them. So thankfully, there is something that can be done about this, and it's changes to legislation. I don't see this happening, but Ontario could revoke the college's mandate to regulate altogether, or they could put some guardrails on that. And Christine, you've been researching this pretty in depth. You've written about it for Macdonald-Laurier Institute in an upcoming paper. You had a few recommendations. Do you want to talk about those?
Yeah, sure. I have a lot to say about this, and my bad legal take actually relates to some public commentary on the Peterson matter as well. But basically, so I have a paper coming out in the Macdonald-Laurier Institute. It's called The New Censorship, because I think this is censorship in its most classic form, even though it's not, a Soviet commissar censoring speech and, watching films in a dark room and deciding what's appropriate for public consumption. It's the same concept. It's government empowered regulators silencing speech because it is controversial or unpopular or outside of the mainstream. And we know, as you referenced, the Supreme Court has actually said it's not, mundane or innocuous speech that gives this right its meaning. It's the controversial speech, because no one comes after and tries to censor, innocuous comments. They come after the types of comments that Peterson made, which are off duty and lack a nexus to the practice of psychology. So regulators don't just have some freewheeling power to discipline members of the profession for everything they say and do. It needs to actually be connected to the practice of psychology. And like Peterson's opinion on aesthetic beauty, or his opinion on Jerry Butts, the prime minister's a principal secretary, or whatever that role is called. It's just not connected to the practice of psychology at all. I mean, no one would think that an accountant, because they lost their temper at a little league game, is no longer competent to perform audits. Like, why do we think because Jordan Peterson doesn't think some lady's hot that he is not competent to practice psychology? Maybe we think he's rude, but that has nothing to do with it. Anyway, I don't want to reiterate everything that you said, so I'll tell you what some of my recommendations to fix this are that are in my forthcoming Macdonald-Laurier paper. First, I think that regulators themselves need to receive comprehensive training on charter rights. The people who make up these regulatory bodies might have technical expertise in the practice of medicine or the practice of psychology, or the practice of accountancy. They might be really amazing accountants, but they don't have any knowledge about the charter or constitutional guarantees. And we've actually seen how the Law Society Tribunal has actually come down more firmly on the side of protecting the right to freedom of expression in some recent cases. And I think that's because lawyers actually have an understanding of the charter right and how to balance it. These regulators who make up these bodies don't know anything about the charter at all. So why are we tasking them with balancing charter rights against public the statutory goals of the regulator? They aren't equipped to do it. So provide them with at least some training. A second thing we can do is have legislatures modify the standard of review. The standard of review automatically in judicial reviews of administrative decisions is reasonableness under Dore, which you've described some of the problems with, this like undue deference. But legislatures can displace that standard. They can statutize a correctness standard, and they could do that for cases that engage the right to freedom of expression. So you could actually solve this problem of deference by doing that. Another thing legislatures could do is put into legislation that there needs to be a nexus to the profession. That's actually already required by the case law. But as we've seen in a lot of cases, including Peterson's, the regulators have this expansive view of their role, and they think that they can regulate but just about anything you say, even if it's off duty. And off-duty speech can be subject to discipline, but it needs to be actually related to the profession. The case law requires that, but making that explicit in the legislation, I think, could help. The last thing I think we need to do is really, it involves a cultural shift. We need to push as a culture and society for what the value of freedom of expression is, what the importance of protecting it is. And because the people who make up these regulatory bodies are pulled from, society at large within the profession, if we have more of a cultural emphasis on the value of freedom of expression, that will make its way into the psyche of the people who make up these regulatory bodies. And I think that we at the CCF are doing a lot on that front to kind of push for that cultural shift with pretty good success, actually, I would say. Joanna, what do you think?
I mean, I don't want to add too much because we've already gone on a long time, but when you said this is basically like a Soviet type speech regulator, it reminded me of this provocative essay that Neil Ferguson published in the Free Press a couple of weeks ago, making the argument that America is basically equivalent to like late Soviet in terms of decadence, in terms of how alienated the elites are from the people, in terms of just like the amounts of deaths of despair that you see. It's a really interesting essay. And obviously he goes into things that are, more qualities of realpolitik and the economy in Canada were just some like weird annex. But we are often like the canary in the coal mine when it comes to the elites and state apparatuses becoming so disillusioned and so enthralled with an ideology that the rest of the population completely doesn't relate to. And I think this is just an extreme example of that. So if we have any American listeners, be careful and watch what your professional regulators are doing, because a lot of how the state actually impacts like the real action of what you tweet, what you say, how you comport yourself, comes down to the sort of beating heart of the middle class, which is professionals. And so there's a lot of hyperbole in terms of like state censorship, although not all of it is hyperbole anymore. We'll talk a little bit about the Online Harms Act, and we've talked about it before. But this is really where the rubber hits the road. And so basically, the College of Psychologists got away with this, and it's pretty crazy. And my last thought is, can we get Chevron? Basically, if you accept that Dore is broadly the equivalent of Chevron in terms of huge deference to administrative regulators, maybe we can get Dore overturned now that Chevron was overturned. Probably not, but
probably not.
10 years from now, maybe.
Yeah.
We'll just get a modification like Vavilov. It's like only a slight.
That was real helpful.
Okay, so I'll talk about my news headline today, which is a case that was recently decided by the Ontario Court of Appeal. and it involves searches of personal electronic devices at the border. And there were two separate cases, Mr. Pike and Mr. Scott. So the case is called R.V. Pike and Scott. So it's unreasonable search under Section 8 of the Charter case. And just as a, advanced warning, Section 8 cases almost always involve brutal facts, like bad facts, because it involves whether or not you should admit evidence that was found on a unreasonable search or a search. And because there is this evidence, it means you found something in the search that is usually not good. And unfortunately, often these cases involve images of child sexual abuse. And that's what this case involves. So if you're listening and you don't want to hear about child sexual abuse, I understand why you might not want to hear about that. That's what I'm going to talk about.
I think the term is child sexual exploitation. I think we'll get dinged if we use that term. So.
Okay. So child sexual exploitation, images of child sexual exploitation. So here's what happened in the case. There's this man, Mr. Pike. He flew back to Toronto from Indonesia, where he had told border officers he was teaching English to adults, but he later confessed that he was teaching English to children. He was a man, he was traveling alone, and his passport had stamps from multiple countries known for sex tourism. And he had previously been sentenced to 15 years imprisonment for possession of child sexual exploitation images. So, suspicious character. He landed in Toronto. He was found with 14 digital devices, which is, more than most of us would travel with. And so the border officers demanded the passwords of these devices, which he then provided. After about 2.5 hours after this initial interaction, he was told about his right to counsel. And then 45 minutes after that, the officer discovered 1,600 images of child sexual abuse and exploitation. So that's Mr. Pike. Mr. Scott was a 77-year-old man who went on vacation to Belize for 6 months by himself. And on secondary inspection at customs, he was found with 13 digital devices. This is obviously a red flag. He seemed nervous. He said that he had all of these devices because he likes to store movies, and the officer did not believe him because that is preposterous. And the officer suspected that he possessed child and was importing child sexual abuse and exploitation content. So the officer demanded his passports, which were provided. He did not inform Mr. Scott of his right to counsel. They searched the devices and they found 3,000 text, image, and video files depicting child sexual abuse and exploitation. So terrible, terrible facts, terrible people. So both men argued that the searches violated their charter right to be free from an unreasonable search and seizure because the Crown was relying on a law for a Canadian Border Services Agency law that gives customs officers numerous powers to search people and goods at the border. And the men challenged the constitutionality of a specific part of the statute, subsection 99 sub 1 sub A, which does not require officers to meet an objective threshold before searching the contents of digital devices. So it authorizes agency officers, without forming any reasonable suspicion that a border law has been violated, and to search any goods that people bring across the border with them or otherwise import until the officers authorize the release from customs. So this is like a much lower standard than a normal search. It is does not require an objective belief that in order to do this search. So the Ontario Court of Appeal found that law does violate travelers' rights against unreasonable search and seizure. And they also found that the border agents had violated these two men's right to counsel. And they also found that in one of their cases that the evidence from the device was inadmissible. So obviously the facts of the case are really bad. And I have to say that I really hate the outcome in this case, which has these monsters who have victimized children given lighter sentences. In Mr. Scott's case, he was given no jail time, despite the many children he victimized. The Crown's appeal was dismissed, and he serves his sentence as a house arrest, even though the court, I think, said that he should have received a 3-year sentence. He was given, I think, a 23-month house arrest. In Mr. Pike's case, the court found that they could have admitted the evidence found on his device, and so he was sent for a new trial. So it's possible that he could get the 3-year sentence. We'll have to, I guess, wait and see. But the issue with these Section 8 cases is the facts are always bad. You really have to think about the legal issues at stake. So let's think about the legal issues. And there are really, really interesting ones, despite me hating part of this outcome. The Canadian Civil Liberties Association intervened in this case, and they said that what this law does is it creates a charter-free zone at the border. And they said that Parliament needs to legislate a standard that is for search that is constitutional with clear safeguards for privacy in our personal devices. I do think that the lack of a objective basis for a search is a problem. But part of this case that I think really stands out, and I think a lot of people will probably discuss and use this case as an example of, is that this is another example of a law being struck down, at least in part, on the basis of the doctrine of reasonable hypotheticals. So a reasonable hypothetical is sort of this imaginary device where it's not enough that the sentencing provisions are reasonable when they're applied to the offender who's currently before the courts, like in this case, Mr. Pike and Mr. Scott. The reasonable hypothetical says that the mere possibility that someone else might be subject to a sentence that's harsher than what the court considers appropriate is sufficient for the court to decide to invalidate a criminal code provision or a law on charter grounds. So it was first used back in 2000. It was used in this case. The reasonable hypothetical that was used in this case was how this law might apply to an 18-year-old instead of these adult men importing child sexual abuse and exploitation images. What if it was an 18-year-old who inadvertently had received and then failed to delete an intimate image depicting his friend's 17-year-old girlfriend, and then he crossed the border? How would the law apply to that man instead of these, adult, in one case, already convicted sex crime offender? So a lot of people have issues with courts striking down laws on the basis of reasonable hypotheticals. It was used in Bissonnette, this Quebec mosque shooter case. It was used in a case called Basso, also at the Ontario Court of Appeal. That case also involved the sexual assault of a minor. It was used in the case of R.V. Noor, which dealt with tougher penalties for child predator, a legislation called the Tougher Penalties for Child Predators Act. And now it's again being deployed in another child sex abuse case. And it's actually I think that this is going to be a topic of political interest because it's the reasonable hypothetical that conservative leader Pierre Poilievre has criticized the courts for relying on this way, and he has vowed to use Section 33 to address by invoking Section 33 to bring these laws back after the courts have struck them down. And honestly, with the outcome that we see in this case, I do understand why the public might support that. Joanna, what's your take on any of this?
Well, it's interesting because I had always understood, and this is the reason why you have this law on the books, that things are different at the border, right? You just don't have the same, as a citizen, you don't have the same reasonable expectation of privacy at the border. Just because it involves international borders, you're considered to be almost like under the custody of the CBSA. They have absolute discretion to refuse entry. I mean, if you're a Canadian citizen, not as much the case, but like you just don't have the same expectation of privacy. You know how many times I've had every single intimate item of mine gone through in my luggage, and like I don't have a charter claim against that. And the basis is just, could be like a random search. So I find this all a little bit odd, to be honest, because there are different considerations when you're crossing international borders. Having said that, I think there's an argument that it's not particularly principled. It's just that there are particular security concerns when you're crossing international borders. So I agree that high level, there shouldn't be a charter-free zone. But I think whatever compromise, if this legislation is going to be struck down or amended, it does need to take it into account that, driving down the street in your neighborhood is not the same as crossing international borders. As for the reasonable hypothetical, we've talked about this before. It is a particularly Canadian sort of wacko thing where judges get to just make up fairy tales that make laws look super unreasonable, and I find it very odd. And yeah, I'm not a fan of it. Basically, is where I come down on the hypothetical. Like, wait until the case actually comes up. That has been the mechanism of the common law. Is that law evolves in response to human circumstances, and you don't just make up the craziest story that you can think of. But yeah, within quote unquote reason. If it's reasonable, then eventually it will arise. Any thoughts, Josh?
Yeah, I have lots of thoughts. I mean, like the facts of this case are awful, and I think one thing that will stand out for listeners is like the fact that you can obviously leave Canada, sexually exploit children, and go to like several countries that are known for that. And I think one or both of these men had a history of this before,
Yeah,
right?
one
Like
of them
they,
had been convicted and served 15 years in prison.
yeah, and then so we know what he's up to when he goes to these countries and comes back with all of these devices, and I think that rises to a level where there is reasonable suspicion. And the fact that you can get as little as 3 years, like the judge here who wrote this was saying, the sentence should have been longer, but since it's already half served or more than half served, I'm not going to change it. But even 3 years to me seems like a light
I
sentence
know.
for that type of crime. But all of that aside, like on the Section 8 stuff, I think this is correct. Like I think the general idea in law has always been like, okay, at the border, it's sort of a special case. You have a lower expectation of privacy, but Section 8 is not about a reasonable expectation of privacy necessarily, in my view. It's more about the idea that we need to require things like warrants and like either a standard of reasonable suspicion or reasonable and probable cause, because otherwise the government is sort of always in control and always able to, just search us and figure out what we're doing, and we end up with no ability to have, private spaces or spaces where we can potentially discuss overthrowing that government if we need to. And the standard here that was selected by the Court of Appeal is reasonable suspicion. That too is a pretty low standard. Like in most contexts, that is the lowest standard, right? So they're saying you just have to meet this minimum level, that there has to be some objective facts here that would make a reasonable person suspicious. Like there has
I
to be
mean, wouldn't
some level of
14
probability.
laptops rise to that? Like you would
Well,
think, right?
one of them, it sounds like the reasonable suspicion was met, but I actually only read part of the judgment and I didn't get there. But
But
if you
both
were
of them had 14 laptops. I mean, that's just like
right,
such a red flag to me. Like that's weird.
I don't think it necessarily is like 14 laptops plus travel to 6 countries known for this type of sex tourism plus
And a
traveling
previous
alone.
conviction.
Well, the
Yeah.
previous conviction, yeah, I mean that alone plus I think that alone might be enough to
But
for
that was the
reasonable
one that's
suspicion.
going back for a new trial.
Right. So anyway, who knows if on the facts, this particular facts, whether that was met, but I just think that standard is the right one, because it's a low enough standard that we can probably maintain security, and that if there is any single objective fact that is points to there being something illegal like child sexual abuse images being imported, a border officer can still demand your password for your laptop or your phone, but the status quo is they can essentially just go through your phone and your laptop, and that is not okay. Like that could be so easily abused, especially think about during COVID if they decided to scapegoat certain people and were willing to go through their laptops and see like, oh, is some, are you going to attend a COVID protest or something? Like we need to keep maintain these standards. And so I think the outcome in that sense is right, even though maybe the sentences are questionable and yeah, the facts suck. So anyway, let's move on, Joanna. Let's hear your headline.
Let's take a break. When we come back, we will talk about Birju Mujahid Dattani. Okay, so front page news this week is that Birju Dattani, who was Minister of Justice Arif Virani's appointment to be the new chair of the Canadian Human Rights Commission, which will have beefed up powers under the Online Harms Act, he put up a LinkedIn post where his verbiage was he has agreed to resign. So he was voluntold to resign. And this comes on the heels of the release of an independent fact-finding report, which was done by an Ottawa law firm, which goes through in great detail the controversy around Dattani's appointment, which, if you'll recall, virtually as soon as he was announced as the appointment, various Jewish groups, Jewish Canadian groups like CIJA, the Canadian Israel Jewish Advocacy Center, Friends of Simon Wiesenthal, B'nai B'rith, all had combed through Dattani's digital record and raised objections that his comments and conduct and participation earlier in his career raised a reasonable apprehension of bias against Jewish Canadians and certainly a strong bias against Israel. And so the fact-finding report goes through in great detail the background of Dattani's, what they certainly characterize as his anti-Israel activism. Although there's a lot more nuance to it, it's hard to not come to this overall conclusion that as an academic, he did, I can't recall if it was a PhD or a master's degree at SOAS, which is a graduate university in London, which, by the way, as soon as I saw that he went to SOAS, which, hold on, let me just look up what it actually stands for so I don't bungle it. It stands for the School of Oriental and African Studies. And it does have a reputation. I lived in London and had a lot of friends that went to LSE and UCL, and SOAS has a reputation for being a very activist and very just like hard left institution. So that kind of raised my eyebrows, but it could be rebutted. But just a few things that the report goes through that Dattani did. He went to a protest of the Israeli embassy in London where there were people shouting death to Israel and, burn Tel Aviv and, things that we see all the time now. But this was like in the early 2000s. He participated in panels in multiple Israeli Apartheid Week events. He traveled to a university in Turkey to participate in Boycott, Divest, Sanctions Week. And the report goes through these participations. And while they say, clearly he had developed an interest and an expertise in the Israel-Palestine conflict and in, the Arab world more generally, and that could actually be useful for this role. The problem they have is that his claim, so his explanation of all of these participations, and there's also journal articles, I'm just giving a sampling of this participation. He claimed that when he participated in these events, it was as some sort of neutral reporter of international law. So he would show up and just say, this is, as a jurist, these are the requirements of international law, and he wouldn't sort of take a position one way or the other. And here's what the report says about that. They basically say, that's too cute by half. They say, we have some concerns with the manner in which Mr. Dattani has characterized his conduct while he was a postgrad student at SOAS. He was forthright at times, sharing that he had been critical of Israel's treatment of the Palestinians. However, on most other occasions, Dattani appeared to characterize his position as detached, or neutral, saying that he focused on the legal framework. And they conclude that this is not really, he was clearly, consistently, trenchantly critical of the state of Israel, and that he deliberately de-emphasized the manner in which his academic work was critical of the state of Israel in respect of its treatment of Palestinians. They do stop short of saying that there's any perception of anti-Semitism, and that's fair enough. But for me, this just already left a bad taste in my mouth. Like, it's just so beggars belief that you would participate in this broad suite of events that are like Israeli Apartheid Week and BDS, which are known to basically have their raison d'etre to single out Israel and just say that you were there to like play umpire. It's just, completely strains credulity. Then they go on to, I think, the more decisive factor, which is this whole matter of whether Dattani appropriately disclosed his name. So he was born as Birju Dattani, and then when he was 21, he converted from Hinduism to Islam, and he took on the name which was recommended to him by an imam, Mujahid Dattani. And there's a few things that he says that under the section of the secure background check, there was a section that asked for primary name, and then it asked for nicknames, pseudonyms, and all other names that you could have gone by with. So he filled out Birju Dattani, and then under the nicknames part, he wrote Birju Mujahid Dattani or Birju M, a few other variations. And he claims that he omitted a comma between Birju and Mujahid. So he meant to indicate that as two different names, but he omitted the comma. And the panel also disagrees with this. They say, we do not find his explanation provided that there was a comma missing to be credible. He also claimed that his choice of name was, as he put it, just whimsical. They conclude that he was, and they put this, I like this term. The lawyers say he was strikingly thoughtful in respect of what names he chose to use and when. So that's a very nice way of saying that he was being opportunistic or strategic. And they find that on panels that were dedicated or geared towards the general academic community of SOAS or other universities, he would go always by Birju Dattani. But on all the panels regarding Palestine, which they say most of which did not appear to be directed at a bipartisan audience, or if the audience was likely to be Muslim, Dattani identified himself as Mujahid. And he also used this for his Twitter account, which was full of lots of retweets of things like, claiming that Israel had created the new Warsaw Ghetto and Israel was an apartheid state. So they end up saying that there are major credibility problems with this guy. The biggest issue is the issue of name. And so with the name, I don't find this credible either, that he omitted the comma. I think he was being deliberately unforthright, and it would have like a clear continuum of conduct with his conduct back when he was a graduate student of switching up names. I guess some people would say that's called code switching, depending on the audience, to tailor himself to project a specific identity to specific audiences. So there's a direct line between that conduct and this. I don't find that credible either. I also don't want to let the government off the hook, because the name was part of his application, and I would think that a thorough background check would look for different combinations. I find it hard to believe that the government didn't find this Twitter account, and it took CJA, it seems like 5 minutes to find it. But look, all of this is kind of neither here nor there. Dattani is out. The current human rights commissioner is going to stay on for another period until they find someone else. And no doubt they'll find somebody else who has a more squeaky clean digital breadcrumb trail, but that doesn't mean that they're going to be better. And moreover, the practice of going in and deciding when speech crosses the imaginary threshold into hate speech should just not be up to the whims of a particular person. You don't like this particular guy because it turns out that he was an anti-Israel activist, which, reading between the lines is what this fact-finding report concludes at SOAS. But there's no guarantee that the next person will be better. And moreover, if it's conservative government, they may pick somebody that has priors that makes them predisposed to leftist activists, and that's not good either. So all of this is just bad news. My friend Den Delmar and I don't know if we plugged this before. We had a piece a few weeks ago in the Hub saying that basically just like the solution can't be to just find somebody that agrees with us. The whole enterprise is flawed, and this whole affair should really make that clear, in particular, in this case, to the Jewish community. So I was reading Peter Menzies this week, who is the former CRTC chair, and he talks about, because right now this has become particularly newsy with the recent riots in the UK, and you have Crown Police Services going online and warning people about what they tweet. And Menzies says the reality is that while Facebook, TikTok, and X can magnify and accelerate both the good and bad in our culture, mobs of enraged people have been hitting the streets since the dawn of time. So just regulating speech and tamping down on edgy speech is not going to solve the problem of simmering rage in our society. Josh, what do you think about this? I know that you guys didn't read the fact-finding report, so are you surprised?
God, you did.
Oh, did you, Josh?
I didn't read it. No, I'm glad that this guy is out, but the problem is not really this guy. The problem is that we're putting, administrative officials who are just employees selected by the government in charge of what we can and can't say. And if Bill C-63 passes, we'll have little committees of Birju Dattanis deciding whether or not the tweets you sent out are discriminatory or whether you're allowed to express yourself on those particular topics. And I think we know how that would play out with these particular types of people who want to sit on human rights tribunals or head up human rights commissions. It's not gonna end well. So we just have to stop policing speech. And if I were the new government, I would just get rid of the Canadian Human Rights Commission altogether. Like, I don't think they do anything useful at this point. I think people are adults and they can figure out how not to discriminate, and that the community can enforce the rules when people do discriminate against people. I don't think I have that much more to say about this. Christine, what do you think?
Joanna, you didn't mention, so he picked the name Mujahid, or I'll say that again. So you said that he picked the name Mujahid for himself when he converted.
Well, I think an imam recommended it, or told him,
But I don't think we discussed what that means, which
Right.
it means one who engages in jihad. And it doesn't necessarily mean you engage in like military war in literal terms. It could mean like you struggle on behalf of Islam.
I think there's something in the fact-finding report that it was like it was picked for him because it meant like brave warrior. So they do water it down a bit, and I don't really want to get it.
Like sure, it's like one of those things that it can have multiple meanings, but when you pick that for your name, and then you've posted all these things that many of us would consider anti-Semitic, or at least anti-Semitic adjacent, and you lie about it, and you have this, like, he had a secret Twitter account, right? Like that was part of the issue. With that name, like, I don't know, maybe it would lead some observers to think that it had a more militant meaning that this selection of the name, even though perhaps not like a literal militant, but certainly it should raise some eyebrows when we consider like the actual name that he selected on the basis of this recommendation. So that's
this whole thing, to be honest, reading through this, I was just like, I just feel like this is one of the biggest mass gaslightings when you look at what's actually going on here. There was a part of the report where he had participated in a panel, I think also at a university in Turkey, called Terrorism as a Strategy. And he's like, but of course, I never would endorse terrorism as a strategy. I would never even conceive that. But it's like, but you sat on a panel called Terrorism is a Strategy. Like, it's just like, it's like, everybody telling me that like 2 + 2 = 5. Like, it's just the underlying what's going on here. Like, I'm sure he's a nice guy and everything, But it's just like,
I'm not so sure. It's possible.
but I just can't believe that the government was so sloppy that they
It's just,
missed this
yeah.
whole, all, there's like just like a sea of red flags behind this guy.
I think that there's a sea of red flags behind anyone who would want this job. Like it's inherently going to attract people who have a particular worldview. And this like view on Israel, I think, is a feature, not a bug, of the people who want jobs like this. Anyway, let's move on. I'm gonna give my bad legal take. And my bad legal take is a perpetual grievance that I have with this account on Twitter called the Canadian Charter of Rights and Freedoms. And I don't know who runs this account, but they do not know anything about the charter. And they're always tweeting the most partisan stuff. The account started as like, it would just tweet like sections of the charter, which is like, okay. There was this, trend a few years ago where you would be like an inanimate object or like an idea, and then you'd like tweet as that object. And it was kind of like cringe funny. Now it's like very played out. But someone is doing this and they're pretending to be the charter itself. But the person who tweets does not understand the charter. So they tweeted about the Jordan Peterson case, and the charter said this is absolutely not a freedom of expression issue. Peterson said his words and wasn't arrested, charged, fined, nor jailed for them. However, the college that he belongs to has a code of conduct he agreed to follow. They believe he didn't follow it, hence the action taken against him. So let's break down this tweet because it's so bad. This is absolutely not a freedom of expression issue. Wrong. It 100% is a freedom of expression case. The court calls this case a freedom of expression case in paragraph 1 of the decision of the divisional court. Part 2, Peterson said his words, wasn't arrested, charged, fined, nor jailed for them. He was not, but that does not have to happen for your freedom of expression rights to be violated. Like censorship does not necessarily always involve jailing the person who is speaking. It can involve all kinds of things, up to including the type of disciplinary action that was taken against Peterson. The last part, however, the college has a code of conduct he agreed to follow. Yes, they do, but it's not like an unlimited scope where they get to police everything that he says and does. He agreed to have his conduct as it relates to the practice of psychology regulated, not to have his opinions on bikini pics regulated, because that has nothing to do with the practice of psychology. They believe he didn't follow it, hence the action against him. I guess that's the only part of this tweet that is not objectionable. That part is accurate, but everything else is wrong. So I tweeted about this and am now in like a war on Twitter against other bad legal take giver, Amir Otteron of the University of Ottawa. So if you want to see me have a meltdown on Twitter, go and check out my feed today.
Or any day.
Or any, not normally not. Like this account really riles me up. I'm just like so mad that someone is tweeting as the charter when they don't know anything about the charter or how it works or what the charter guarantees. Like it's so enraging to me. Okay, Josh, how about you?
All right, my bad legal take goes to the BC Civil Liberties Association, which has gone full communist, and I suppose it was only a matter of time. The BCCLA historically was a well-respected, quite far left-leaning civil liberties group, but one that we would have agreed with a lot. And they got into a bit of hot water 2 years ago. You may recall when their then executive director, Harsha Walia, tweeted, "Burn it all down," in direct reference to two churches that had been burned down in the wake of the discovery of 215 unmarked graves at Kamloops, BC, or at least reports of that. And Walia ended up stepping down, but and she found a new vocation, which is basically the anti-Israel protest circuit. She can now be found doing things like blockading rail lines. But even with Walia gone, the BCCLA continues to be like way out there on the fringe these days, because this week they tweeted that they're in court intervening on behalf of Vancouver Island University students who continue to occupy the campus in Nanaimo, BC. And I guess they haven't gotten the memo that the encampments are 3 months ago because they're still out there with their tents. The BCCLA writes on X, protest is a fundamental right. We all need to be able to rely on our charter rights of free expression and assembly. This should still be true when we're protesting against those claiming to own property like corporations or universities. Too often we see companies and institutions quickly given an injunction by courts allowing police to remove protesters from property. This suppression of protest and dissent is the opposite of a free and open democracy. Having protesters removed from private property is not suppression of protest and dissent because there isn't and never has been a right to occupy private property. And this was well canvassed recently in the University of Toronto injunction decision, and so I won't get too deeply into that, but private property is the institution that's allowed individuals to stop being serfs and become masters of their own destiny. It's allowed businesses to flourish that create wealth and employ people, knowing that other people can't just step in and take it all away. And if anyone can just occupy whatever private property they want whenever they want to protest, then we're back in a barbaric age where whoever has the most muscle can just take what they want. And it would look a lot like Haiti right now, where there's, roaming gangs fighting for territory and just taking whatever property they want because there's no one left to enforce the rule of law. In terms of this being a bad legal take, it's simply not true that property rights not being in the charter means that they, don't exist and can always be overridden by expression. The charter did spell out on paper, some details of rights that are now constitutionalized. They were before too. But the rights we had before 1982 continue to exist even if they're not in the text of the charter, and the charter itself recognizes this, and so has the Supreme Court. For example, in Annapolis group in Halifax, a case that we intervened in after Halifax took a developer's land and made it unofficially into a park, the court said, quote, "It is, of course, true that the framers of our Constitution did not include the protection of property rights in the charter, but the charter is not and never has been the sole source of Canadians' rights against the state. In particular, the common law also affords protections of individual liberty. Section 26 of the Charter itself affirms that, quote, the guarantee in this charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada." And Professor Leonid Sirota had a great response to this. He wrote on X, "There are no rights and liberties without secure property rights. Nice church you've got there, we'll protest there instead. Nice newspaper, we'll occupy it. Nice club, we'll take it over. That a self-styled civil liberties organization cannot see this is a disgrace." Joanna, let's hear your BLT.
So my BLT goes to Warren Kinsella, who is urging on Twitter that Canada must ban the hate symbol of the inverted red triangle, which has been used at many, frankly, pro-Hamas or more broadly pro-Palestinian rallies. We saw some pretty alarming scenes last weekend from Ottawa where people were literally carrying a banner phrasing arm resistance on Hamas, which we know when Hamas does that, what it looks like. It directly targets civilians and is terrorism. Nonetheless, banning a red triangle, I went through, here are some companies that use red triangles as their logos. HSBC, Reebok, Guess, includes a red question mark that ends in a red triangle. Toblerone, Mitsubishi, of all those red triangle logos driving on the street. Caterpillar, Adobo, Airbnb, and not to even to mention Canadian Tire. So no, it's not workable to ban a red triangle. Moreover, just wielding a hate symbol, banning it, criminalizing it, doesn't make these nasty people change their minds or go away. There needs to be more context, and it needs to be connected to a pattern of conduct that is promoting terrorism. So we understand that it's upsetting, and I agree that it's not innocuous in the context of many of these rallies. We know what they're referring to, but sorry, bad legal take to think that we can criminalize and ban a red triangle.
All right, that's the show. So as usual, we hope you'll rate us, review us, and subscribe. And if you haven't already, please go to our website or click on the link in the show notes to fill out a brief survey to tell us how we're doing. And you can support our work by subscribing to our YouTube channel, which just passed 80,000 subscribers, I believe, by following us on X or by visiting our website, theccf.ca, where you can sign up for a weekly Freedom Update newsletter from our colleague Russ, where you'll get a weekly roundup of the news headlines that we're interested in, plus all the work that we're doing. The CCF is a nonpartisan legal charity funded by your donations, so please click that donate button on our homepage if you can. Thanks for listening.